So we continue. So in this second part, I will first give you a brief overview of the codification of general international water law. So how did it come about? And then after that, I will look at the two main principles of international water law. The equitable and reasonable use principle and the principle of no harm. So first, the codification of general international water law. It's a long story, but the highlights of it are pretty well known. So it all starts with the International Law Association. I don't know if you are familiar with this organization. It's an international gathering of mostly scholars, but people that have an interest or expertise or experience in international law. I'm also a member. So they all have these national branches, and then your national branch can nominate you to become a member of the ILA. And the International Law Association, made the first serious effort to codify existing rules of customary international water law. And they did so in the 1966 articles on the uses of the waters of international rivers, the so-called Helsinki rules, because then the meeting of the Law Association was in Helsinki, in Finland. This year, in a few months, next month, it's in Sydney. And 2 years ago, you are from, yeah. I'm not going there, it's too far away. But you could go there if you're in the, oh you are, yeah. So a lot of my Dutch colleagues, they are very loyal visitors of these meetings. I was there in Johannesburg, but this time I don't go. So the IA has all these small working groups, and they then draft these rules. And one such working group was devoted to the uses of the waters of international rivers. And sometimes these draft articles of those ILA groups are very influential, and sometimes they are not. And this is a very successful attempt at influencing the development of international law. So it's International Law Association is only a group of academics and practitioners of international law, so has no formal role or legislative power, but sometimes it's very influential in the making of new treaties or even in making of custom. So a bit about the Helsinki rules, adopted in 1966. They are available on the website of the ILA, and they are a bit like the commentaries of the International Law Commission. So you have the article, and then with the commentary, which sort of explains how they got to the exact formulation of the article. And it's still very useful to read those Helsinki rules, because there's a lot of references to state practice from predating 1966, because the ILA really wanted to make an attempt at codifying existing international water law, and not in sort of drafting a treaty on how they saw international water law in the future. So they really tried to base their work, to ground their work in existing state practice and opinion juris. Their rules, the Helsinki rules, were applicable to the use of the waters in an international drainage basin. So not an international watercourse, that's a term that the UN Watercourse Convention adopts. But here it was the international drainage basin, and that was defined as an area known as the watershed that contributes water both surface and underground to the principal river, stream or lake. So it's a bit similar to watercourses, to the definition of the watercourse in the 1997 treaty. Because it does refer to this unity of surface and groundwater. It also included a section on navigation of rivers and lakes, And as I said, that is sort of exceptional because the more modern treaties do not refer to any such rules and rather leave it to the specialist of transportation law. So what kind of rules do we find in those Helsinki rules? Well, first something on the relation between those general rules and the more specific rules. That is always a bit of a tricky issue. As I told you before, we have the 1906 treaty between Mexico and US on the Rio Grande. We have well, attempts at concluding a treaty specifically on the Nile. We have a treaty regulating the use of the Rhine. We have a treaty regulating the use of the Danube. So a lot of specific watercourses are regulated by a specific treaty. So these general rules, how useful are they then? So that's something that ILA was struggling with, and they decided that these general rules that they've adopted can be overruled by more specific, watercourse-specific treaties if the circumstances so require. And interestingly, already in the Helsinki rules, the primacy, the focus was on the reasonable and equitable use principle. So what did the Helsinki rules say about reasonable and equitable use? Well, in the commentary you see that they clearly distinguish between equity and equality. So equitable use does not mean, if you share a river, it does not mean you get 50% of the water and the other state gets the rest, the other 50%. In any case, it's very misleading to think about waters in this way because the water flows from its source into the sea, and of course it's not the idea that the first state uses up 50% of the water and the other state the other 50%, so that not a single drop ends in the sea, and no river is used in that way. So please don't refer to a river as a sort of cake made of water that you then divide into equal portions. That's very often done. I find that a very unhelpful metaphor, because sometimes rivers are used in such a way that the quantity or quality of the river is hardly affected, but they are still very actively used. And for tourism, for example, that could be an example, but also to extract energy for recreation. And a lot of these practices don't really require taking of water. Of course, agriculture is different, but even if lots of water is taken from the river for agricultural purposes, it doesn't mean the river is reduced by, say, 80% of its size. Beneficial use. According to the Helsinki rules, states are entitled to a reasonable and equitable share in the beneficial uses of the river. So what are beneficial uses? Those are uses that are economically or socially valuable. So economically, think of agriculture, but also water used to cool factories, or water used to dump some of your waste. Socially valuable, and think more of human right to water and sanitation type issues. There's no mention in the Helsinki rules of the ecosystem approach, preservation of freshwater ecosystems. You don't find it. You don't find any references to protection of the environment or sustainable use of the river. I guess in the 1960s that was not really the big concern. Obligation to prevent pollution, yes, you see that too already in the Helsinki rules as a kind of a precursor to the general no harm rule. Then the ILA gave the baton to the United Nations, so it was up to them to finalize this codification effort of customary international law. It was the suggestion of the Finnish government, so Finland, that the ILC should take up the issue of drafting, codifying the existing customary international law on freshwater use. It took a while, it always takes a while. I don't know if any of you is familiar with the ILC articles on state responsibility. It took about 50 years to make. This one took a bit less, but still a significant period, 25 years more or less. The ILC worked on the articles, and so in those 25 years, a list of special rapporteurs succeeding each other, beginning with Richard Kearney, then Stefan Schwebel, very famous American lawyer, Jens Evensen, Stephen McCaffrey, and Robert Rosenstock. And of those rapporteurs, Stephen McCaffrey is by far the most influential. He is basically called Mr. International Water Law. He's still alive. At the beginning of my lecture before the break, I referred you to those lectures of the Audiovisual Library of International Law. So Stephen McCaffrey, gives the introduction to international water law. And he is best suited to do this of anyone in the world. So what were the difficult issues at the time? The difficult issues was the scope. And so what are we going to talk about? The use of what exactly are we going to regulate? And instead of international drainage basin, that's the term the ILA used, they decided to use the term watercourse, defined as a system of surface waters and groundwaters constituting a unitary whole. So what is very important is that a watercourse is a system of surface waters and groundwaters constituting a unitary whole. And this has been interpreted as excluding confined aquifers, and that's really important. So a watercourse must have a connection to the surface. And so fresh water that is entirely situated underground with no connection to surface water is not a watercourse, and is thus excluded from the scope of the UN Watercourses Convention. And that, as we shall see, has really big consequences, unfortunate consequences. So watercourses can be lakes, can be rivers, can be glaciers, can be also artificially constructed canals. And there's a case now before the International Court of Justice on the Silala River. It's a river between Bolivia and Chile. And one of the contentious issues is whether this is actually a transboundary river, because it sort of became transboundary due to a canal constructed by a Chilean-based corporation. So it was not naturally transboundary. But it's okay. Those are also within the definition, I would say. So the only thing that is not within the definition of a watercourse is a confined aquifer. So an aquifer entirely situated on the ground. The idea from the beginning was to draft a framework convention which should be complemented and adjusted if necessary by regional or water-specific agreements. So that's this bullet point. So here the ILC is following the ILA and suggesting, okay, we're going to give you these general rules, but if they don't work for a specific watercourse, then states are free to adjust those general rules, but they should in any case try to stay as much as possible within the general framework. And here they disagree with the ILA. The choice was made from the beginning to exclude the issues of navigation from the work of the ILC, and also to exclude any issues related to the delimitation of a boundary that runs through the river. So those issues are not covered by the ILC articles on watercourses. Another contentious issue was dispute settlement. As I will explain later, a rather complicated dispute settlement procedure is included in the Watercourse Convention, but it has never been used. So after the ILC was done with the preparatory work, so they produced a list of articles with commentaries in 1994, and then between 94 and 97, so only in 3 years, the states, they took up the work. So on the basis of the ILC's articles and commentaries, they drafted the convention. So it was adopted in 1997, the convention's text, and it took a really long time, as you can see, to enter into force. That's because 36 states parties had to be, the UN Watercourse Convention had to be ratified by 36 states before it could enter into force. And that only happened in 2004 with the ratification by the Treaty of Vietnam. After Vietnam became party, only Palestine acceded to the convention. So we don't have all that many more states since its entry into force. So it's not a particularly popular treaty, and there are various reasons for it, but it's good to keep this in mind. So it purports to provide a universal framework for international water law, but in fact only 36 out of 193 states are party to it. In many ways that's not problematic because the International Court of Justice has in many cases affirmed the customary nature of its main principles. So those principles would then apply as customary international law also to non-state parties. Palestine is, of course, for many reasons, an interesting case, but unfortunately, many of the neighboring states are not party to the Watercourse Convention. Israel is not party. So then, Palestine cannot invoke the Watercourse Convention against Israel, but of course it can rely on the convention as a reflection of customary international law. Attached to the UN Watercourse Convention, and this is important, is a legally non-binding resolution on confined transboundary groundwater. So why was that done? Because the UN Watercourse Convention itself does not apply to confined aquifers, as I explained. That was because different people disagreed as to whether the general framework was suitable to apply also to transboundary confined aquifers. So then a kind of compromise position was reached, and that was the adoption of this resolution, which basically encouraged states to apply the Watercourse Convention's principles also to confined transboundary groundwater. But they were not obligated to do so. It was just a voluntary commitment on their behalf. And then, because the ILC was a bit concerned with the sort of non-regulation of confined aquifers, so they decided in 2008 to draft articles specifically on aquifers. So that's the law of transboundary aquifers. Those articles were adopted in 2008, and they are applicable to all transboundary aquifers. And they are defined as permeable water-bearing geological formations, rock, gravel, or sand, underlain by a less permeable layer and the water contained in the saturated zone of the formation, parts of which are situated in different states. So think of the drawing I made, and then think of a hamburger. So you have solid rock, That's the breadth, solid rock, solid rock. And in between you have this porous rock, gravel or sand, which sort of absorbs the water like a sponge. That's an aquifer. And the ILC articles of 2008, confusingly enough, apply both to confined and non-confined aquifers. And that means they partly overlap with the UN Watercourse Convention. So this is a sign of not too careful drafting. So confined aquifers are regulated by the 2008 Articles on Low Transboundary Aquifers, but aquifers that have a connection to the surface, they are regulated both by the UN Watercourse Convention and by these articles. And that's problematic because in some ways the ILC articles of 2008 and the UN Watercourse Convention of 1997 seem to conflict with each other. But they apply to both to these non-confined aquifers. So that's a problem. And very few transboundary confined aquifers are currently subject of a specific agreement between the relevant states. I don't know why that is. Maybe they are less visible to the world. So there's not immediately perceived interest in concluding a specific agreement. So most of these specific agreements relate to rivers or rivers that are connected to aquifers. But there are very few treaties regulating specific confined aquifers. And that's what necessitates the need for these general rules. So what are these general rules? Well, the most striking of those is that they are all about sovereignty. So, according to the 2008 rules, any state has sovereignty over a portion of a transboundary aquifer within its territory. So, in that sense, groundwater, confined groundwater, is very much treated like oil and gas, because if you happen to have big oil reserves on your territory, then they're yours, you're lucky. If you don't have oil reserves, then you're unlucky. Same with gas. If you take my country as an example, we have huge gas reserves in the north, and that is, for many reasons, what caused us to be relatively prosperous and rich. We could just take from the gas and provide our entire country with relatively cheap electricity. And of course in the Middle East you have a lot of states that are lucky in a similar sense, that they have huge oil reserves. But is groundwater, is it the same? So if you are provided with lots of underground water, does that mean it's yours and you can use it as you see fit? Or is water different from oil and gas? So basically the draft articles on aquifers almost equate oil and gas with this confined water. In most cases fossil water, so if you drink it all up, it's gone. It doesn't replenish. Yeah, and that's of course very different from the UN Watercourse Convention, which does not, as I tried to explain before the break, which does not see freshwater reserves as the sovereign property of the state in whose territory the water happens to be located. So you see the problem if you apply these articles and the UN Watercourse Convention both to these non-confined aquifers, because they have a very different approach. The ILC articles do refer to the principle of equitable acceptable and reasonable use in the 2008 article. So in that sense, the overlap with the UN Watercourse Convention is much less problematic. There's also reference to the non-harm principle and to some environmental law type provisions. The protection and preservation of ecosystems that are reliant on these aquifers and prevention of pollution of aquifers. So basically we have now the UN Watercourse Convention and we have the ILC articles on transboundary aquifers. What I did not mention is the Helsinki Convention, concluded by the UN Economic Commission for Europe. Essentially this was a purely European convention, so only European states could accede to it. But it recently opened up, so now all states in the world can become party to this UNECE convention. For a long time, no states outside Europe showed any interest in doing so, but then last year, Chad became a party, and that's the first non-European state to do so. And I very much hope that other states will join will follow the example of Chad. Chad is in Africa, I think it's everybody knows. Because then we have two competing or coexisting at least global frameworks on international water law, the UNECE Convention and the UN Watercourse Convention, and then we'll just see who is the most popular. Some states, including my own, the Netherlands, are party to both the UN Watercourse Convention and the UNECE Convention. That's problematic in some ways because they are not entirely consistent with one another. So the UNECE Convention is a bit stricter. For example, if you become party to the UNECE Convention, you have to make treaties regulating each and every international watercourse that you share with your neighbors. And the UN Watercourse Convention only encourages states to do so. And there are some other differences too. The UNECE Convention focuses more on the no harm principle, and the UN Watercourse Convention focuses more on the equitable and reasonable use principle. And in many ways the UNECE Convention is much greener, and so it has much more detailed provisions related to the protection of the freshwater environment. So that kind of brings me to those principles. So that's the topic of the next part of my lecture, the principles of international water law. And now we really get to the heart of international water law. So these principles you find in the UNECE Convention and in the UN Watercourse Convention as general principles, but you also find them applied to and adjusted to specific circumstances in all specific water law treaties. The Rhine Treaty, the Nile Treaty, there's no such thing. The Rhine Treaty, what else? Yeah, the treaty on the river Mekong is interesting because China is not a party, but all the other states are. The Danube Treaty. I understood that there's one person here from the European Union, from Spain. Yeah. So maybe for you it's interesting to know that in the European Union, the management of transboundary watercourses is also regulated by EU law. So there's a Water Framework Directive, which is very detailed and basically provides us with the rules on how to manage and exploit shared watercourses within the Union. So we as member states, we basically gave up our competence to regulate international freshwater use. So we left that competence now to the Union, mostly. It's a shared competence. But that's very specific to the Union. But it's, for example, it's interesting when you look at the Danube Convention. I don't know if you can picture the Danube. For example, the Danube ecosystem is much bigger than the Danube itself. So for parts of Ukraine is situated far from the Danube, but still parts of the territory of Ukraine are within the Danube's ecosystem. So they rely on the Danube for water. And that is why Ukraine is a party to the Danube Convention, which makes the Danube Convention interesting because now we have predominantly EU member states, but we also have Ukraine and Bosnia, I think.
What about volcanic sources?
Sorry?
Volcanic sources. For example, James some aquifer, and around this place, the agricultural activities can be very productive.
Yeah.
Regulates by this convention in international level.
Yeah. So if this water is entirely confined, so it's not connected to any lake or river, then it's regulated by the ILC articles on aquifers.
Some deep surface.
Yeah, then it's regulated by the UN Watercourse Convention.
Not ILC.
No. If there is any connection to the surface, then it's covered by this one. Yeah. So we have now two framework conventions, the UN Watercourse Convention and the UNEC Convention.
Signing escapes, how many?
Sorry?
Signing escapes, how many?
36.
36.
36. Yeah. So it's not many, not much. And they're almost all European states. But it's an interesting question. So many states decided not to sign this convention because they don't see any benefit of a framework convention when they have already regulated all their rivers. The US is of this opinion. So all the rivers or lakes or aquifers that the US shares with either Canada or Mexico, its neighbors, is regulated by a specific treaty. Think of the Rio Grande Agreement. Yeah, but other rivers have their own treaty. And then you could argue, what's the point of concluding a framework agreement with general rules if you already have rules for every single international water? So what's a framework convention? A framework convention, that's from the preamble, will ensure the utilization, development, conservation, management and protection of international watercourses and the promotion of the optimal and sustainable utilization thereof for present and future generations. So that's the general ambition. And states are then encouraged to conclude watercourse agreements which apply and adjust the provisions of the Framework Convention to the characteristics and uses of a particular international watercourse. But they are not obliged to do so, they are only encouraged to conclude those watercourse agreements. And those specific agreements are then, of course, to be considered lex specialis, and they overrule the Framework Convention in case of conflict. They also overrule the general rules of customary international law. So, for example, Turkey is not a party to the UN Watercourse Convention, So you can only apply it to Turkey as a codification of custom, but then Turkey is free to conclude agreements with its neighbors and diverging from those general customary rules. But the obligation of the parties to such specific watercourse agreements is to interpret those agreements as far as possible in line with the general principles of the convention. So there's a duty to interpret away any apparent conflict between the specific agreement and the general rules. So this, we already covered a little bit the scope, but it's really important to put emphasis on this issue. So the UN Watercourse Convention applies to international watercourses defined as system of surface water and groundwater, parts of which are situated in different states, constituting by virtue of their physical relationship a unitary whole, and normally flowing into a common terminus. So this definition excludes confined aquifers, confined groundwater. The UNECE Convention has a different scope. It applies to any surface or groundwater which mark, cross, or are located on boundaries between two or more states. So the UNECE Convention includes both confined and non-confined aquifers and also surface water. And then you have the IOC articles on transboundary aquifers, which is not a treaty, of course, so it doesn't really apply to any state, but again, they are a reflection of customary international law. And those apply to all transboundary aquifers, confined or not. So if you want to make a diagram, then this is the ILC articles. They apply to all, to both types of aquifers, confined and non-confined. Yeah, so this is confined aquifer, and this is a non-confined aquifer. So they apply to both. And then you have the Watercourse Convention, which applies to non-confined aquifers and to surface water. And that's the UN Watercourse Convention. And then you have the UNECE Convention, which applies to everything. So they have, the three treaties have different scope of application, which is sometimes a bit confusing. So to non-confined aquifers, you have three different legal instruments applicable. To confined aquifers you have two, and to surface water without aquifer you also have two. As you can see, all three conventions, they basically focus on the watercourse itself, not on ecosystem. And for this they have been criticized a lot, especially in recent times. And that they focus too much on the river or the lake or the aquifer, but they don't consider in sufficient detail the function of this river or lake for the land next to it. So in more recently concluded agreements, you sometimes see that their scope of application is the freshwater ecosystem taken as a whole. And that makes sense because some practices of the land on the banks of the river can influence the health of the river. So, for example, if you use poison, for example, to fight insects on your land, then this poison can seep into the ground and end up in the river and pollute the river. Also, if you engage in extensive logging, you cut lots of trees next to the river, that can have very serious consequences to the river as well. And all this kind of stuff is not regulated by those conventions, and that's really unfortunate because many of these type of land activities are just as harmful to the river as direct pollution of the river itself. Also, the conventions do not pay too much attention to the connection of fresh water to salt water. There's just an isolated provision in the UN Watercourse Convention on the effects of freshwater pollution on the marine environment. Article 23, which says that states must, when using the watercourse, take all measures to protect and preserve the marine environment. But it's a really big problem, and the pollution of the marine environment via a river. This is a big problem in the Black Sea, for